In this video, you will learn the meaning of the elements contained within a Director Penalty Notice from the ATO and how each element can affect your options for dealing with the notice. I'm Michael Buscema, Practice Lead for Tax Disputes at Aptum and former Acting Assistant Commissioner at the ATO. A big part of my role at the ATO involved steering the ATO's post-COVID-19 debt recovery strategy, including for debt collection tools such as Director Penalty Notices. A Director Penalty Notice, or DPN, is issued by the ATO to recover unpaid company tax liabilities, including pay-as-you-go withholding, GST, and superannuation guarantee charge from directors personally. Typically, the ATO has issued DPNs after repeated attempts to contact the company for payment. However, DPNs are now being issued to directors earlier. The DPN that you get in the mail is made up of two parts: a cover letter, which explains what penalty that debt relates to and explains your options, and the notice itself, which provides for the same information, but also breaks down the periods for which you have the penalties. These are the elements of a DPN to inspect to understand your options. The first thing to check is that your name and address is correct. Check it against the address registered with ASIC at the time that you got the notice or with the ATO with your director ID. If your address is incorrect, there may be grounds to have the DPN made invalid. Next, check the date of issue. Once you receive a DPN, you have 21 days to take action to avoid the ATO taking steps against you personally. It is important to note though that these 21 days start from when the ATO posts the DPN, not the day you receive it. What you need to do. If you are within the 21-day period, it is recommended to urgently contact an insolvency practitioner to understand your options, which can involve taking steps to place the company into administration or liquidation, or appointing a small business restructuring practitioner. If the 21-day period of the DPN has expired, it is recommended to seek legal advice. This can involve assessing whether the underlying liability of the company is correct, whether the ATO served the DPN correctly, or whether any statutory defences apply. Failure to act can involve further action being taken by the ATO to recover the director penalties. This will typically start with the ATO calling you to recover the liabilities. They might refer your debt to a debt collection agency to recover. They might also begin taking your refunds that you're expecting to offset against your tax debt. When it gets to the pointier end, the ATO can send what are called garnishee notices, which require third parties that hold money for you to pay that money to the ATO instead. And eventually they might also take action to recover that amount by getting a judgment to the court before bankruptcy. Disputing the director penalty. There are three statutory defences for DPNs. The first defence can apply in circumstances where for illness or some other good reason, you were not actually involved in managing the company at the relevant times. Importantly, it needs to be unreasonable to expect you to have managed the company. The second defence can apply where you took all reasonable steps to ensure the company met its obligations. Alternatively, that there were no reasonable steps you could have taken. Importantly, this needs to be shown from the period the liability first arose, not simply when you received the DPN. The third defence is only available for superannuation guarantee charge and GST, and it applies in situations where directors took a reasonably arguable position in essentially calculating these liabilities. Understanding the DPN amounts. I will go through two DPNs, one involving GST and one involving superannuation guarantee charge, to talk to you about how to interpret them. In order to understand your DPN liability, it's best to look at the actual Director Penalty Notice and the table that starts on page 3. This table has 5 columns. The first column relates to the periods where the company has incurred the liabilities. So in the case here, there's quarterly periods where the company has incurred GST debts. The second column provides how much debt was reported or alternatively assessed by the ATO for each of those periods. Column 3 details how much the ATO says is left outstanding for the amounts reported in column 2. Now sometimes those amounts can be the same, but where payments are made, they can be lower. And in this example, you can see for most periods, there's been no payments according to the ATO for the reported amount of GST, except for the last quarter where there have been payments and there's only $7,000 left outstanding. Now, in terms of your options, it's important to look at columns 4 and 5. Column 4 are all the amounts where there are penalties where, according to the notice, you have the option to potentially remit the penalties by putting the company into an insolvency process, either through appointing an administrator, appointing a small business restructuring practitioner, or to begin winding up the company and essentially put it into liquidation. If within 21 days you take one of these steps, the penalties detailed in column 4 will be remitted. What remitted means in this case is that those penalties go away. Where people get caught out sometimes though is column 5. The amounts in column 5 represent amounts for periods where lodgements occurred In the case of GST, and it also happens for pay-as-you-go withholding, where amounts are reported 3 months after the due date. If this occurs, amounts in column 5 are what the ATO refers to as locked down. If you've got a lockdown penalty, even within the 21 days, you cannot remit that penalty by taking one of those 3 steps I mentioned before: the administration, the restructuring practitioner, or the winding up. The only way to remit penalties in column 5 is to pay them as per this part of the notice. Even if you place the company into liquidation within the 21 days, the penalties detailed in column 5 will not be remitted because they are locked down. Now, the key difference with an SGC DPN is that the rules around when these DPNs are locked down are different to GST and pay-as-you-go withholding. With GST and pay-as-you-go withholding, those column 5 amounts are locked down if the company hasn't reported those liabilities within 3 months of the due date. The test is more strict for SGC. If you don't lodge the SGC statement by the due date, then these penalties are locked down. So the table that you will see on the Director Penalty Notice will look a little different as a result. In this DPN, you can see that there are no options detailed to remit the penalty by placing the company into some form of insolvency. This means that all the penalties here in column 3 are locked down, and the only way to have them remitted is by paying them. But what if you disagree with the amounts in the DPN? If you disagree with the amounts in the DPN, there are potentially options to dispute those amounts. Those options are for the company to dispute those amounts. Now, what your options are depend on what tax type it is. So for GST and SGC, your options will look a little different than it would if you disagree with the pay-as-you-go withholding amounts. For pay-as-you-go withholding, to adjust these amounts, if you're not in litigation with the ATO, you can provide a statutory declaration. But if the ATO has commenced proceedings to recover the debt, you need to lodge an affidavit. The important thing to consider in challenging these amounts is whether or not the company reported them themselves. More often than not, the company will report these amounts to the ATO, and the DPN is just for the amounts that the company reported. In these situations, there's often not a basis to challenge the amounts because the company has determined them themselves. However, there can sometimes be errors, or there can be situations where the ATO has audited these amounts and come up with their own amounts. In these situations, you can come to Aptum for advice to go through your options to dispute. If you're considering lodging a defence to the director penalty claim, it is important to know that lodging a defence does not pause the 21-day period. If you are within the 21-day period, it is appropriate to get advice from an insolvency practitioner as to your options before strictly considering whether a defence applies. If you would like to have your DPN reviewed or understand your risk of being issued with the DPN, book a DPN diagnostic call with me today, a no-cost 15-minute consultation to understand your options. Thanks for watching.